docket?
Yes, Judge, sorry, I was getting a notice. It's $15,000, Your Honor, but there is an ICE hold. So I was going to say at this time, we don't need a bond hearing because of that pending hold.
Does he require an interpreter?
Yes, he would, Judge. I believe he only speaks Spanish.
Are you comfortable communicating to him that intention?
Hey, Judge.
Yes, Judge, I can do that.
Ms. Lerma just stepped.
Let me mute my other Zoom hearing. Sorry, Judge.
If you'll just let him know, then I will quickly put on the record so we don't have to take the time for an interpreter
Okay.
to put that on the record, please.
Sí, señor, ¿me escucha?
Sí,
Sí, soy su abogada designada de su caso. Hoy era una audiencia para una fianza, pero el problema es que inmigración dice que no le van a dar una fianza. Entonces, yo lo voy a ir a ver en el cárcel para hablar de su caso.
ok, está bien.
Hoy no vamos a tener la audiencia.
Ok,
¿Ok?
ok.
Thank you, Ms. Lerma. Let's call it very quickly. Ms. Wright, calling cause number 2023-04072, State of Texas versus Hugo Daniel Dolorias Aguilera. May I have announcements, please?
David Vandenberg on behalf of the state, and I am substituting for BPU today.
Okay.
Veronica Teresa Lerma, Your Honor, on behalf of the defendant. We are not ready to proceed on the bond hearing.
And it was discussed off the record with defense counsel and her client in his native language of Spanish that there is an ICE hold. Is that correct, Ms. Lerma?
Yes, Your Honor, that's correct.
And with that understanding, I believe your client was in agreement to waive today's bond hearing. I will let you know, Ms. Lerma, that in the event you need to come back, just feel free to contact the court and we can readdress the bond.
Yes, Judge. Thank you very much.
Thank you for your time.
Thank you.
Gracias, Mr. Aguilera. Who's next?
Mr. Parra is back, Judge.
Okay, Mr. Parra. Are we ready to go on Tarin?
We are, Your Honor, and apologies. Part of my confusion is that I was seeing some of the notes back when the offer was 3 years and before, after discussing that with the court, having to go back to 5, Judge. And Ms. Elizalde's most recent statement was that things would be, excuse me, pled to as originally indicted, Judge.
Okay, okay, but I guess where I thought we had, maybe I want to make sure we're on the same page that I intend to make the deadly weapon finding in that case in 4719 as to count 1. So I need to know if that's what you're going to do with that, if your client still wants to proceed or not.
Yes, Your Honor.
Okay. Mr. Tarin, come on in. Or Annex, can I have Mr. Tarin, please?
Yes, ma'am. Give me 1 second.
I do remember the plea paperwork being fairly lengthy, so I had done a cheat sheet, so to speak. Okay. Mr. Tarin, we're going to get back on the record. Erica, were we just at entering of pleas as to cause number 4719?
You were asking if that was the agreement. So you got to 4719 and then it got stopped at the deadly weapon.
Okay. And he had already entered his pleas as to 3238, right?
Let's see. Yeah, we have 1 guilty. I just see the 1 charges. I just see the 1 guilty happening and then I go to 4719.
Okay. So we are back on the record in cause numbers 2022-0D03238, 2022-0D03572, 2022-0D04719, 2020-0D05125, 2023-0D02136 and 2022-0D05573. All cases styled the state of Texas versus David Tarin. Mr. Tarin, we were discussing your plea. Do you remember everything we did up until this point where we took our break?
Yes, ma'am.
Okay. By my notes, we had already entered pleas in cause number ending 3238. I am now asking about cause number ending 4719. As to count 1, aggravated assault with a deadly weapon, what is your plea, guilty or not guilty?
Guilty.
And as to count 2, injury to a child, elderly or disabled with the intention to cause bodily injury, what is your plea, guilty or not guilty?
Guilty.
In cause number 2022-0D05573, the offense is deadly conduct discharging a firearm. Sir, what is your plea, guilty or not guilty?
Guilty.
Are you making each of these pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor, in these 4 causes, we'll start with 0D03228 aggravated robbery. Had these matters gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 4th day of August, 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, David Tarin, hereinafter referred to as defendant, did then and there, while in the course of committing theft of property with intent to obtain or maintain control of the property, intentionally and knowingly threaten or place SM, a minor, in fear of imminent bodily injury or death, and the defendants used or exhibited a deadly weapon, namely a firearm. It is further presented that a deadly weapon, namely a firearm, was used or exhibited during the commission of the charged offense, and the defendant used and exhibited the deadly weapon. In the matter ending in 3572, there are 2 counts. The state would have been able to prove beyond a reasonable doubt that on the 25th day of June, 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, David Tarin, hereinafter referred to as defendant, did then and there, as a member of a criminal street gang, intentionally and knowingly commit the offense of aggravated assault with a deadly weapon.
Mr.
It is further-
Vandenberg, if you would, let me just interrupt you here for 1 second. I think I have made a mistake here. Did I don't believe we have gone over cause number 3572 and his pleas on that case.
Okay,
So my apologies. Let me stop you right there. If you'll just put a sticky on your summary and let me go back. Mr. Tarin, I am going back to cause number 2022-0D03572. In that case, you were charged with 2 counts. 1 being engaging in organized criminal activity. Actually, they're both engaging, but I understand on that case through negotiations, count 1 is being reduced to the lesser included offense of aggravated assault with a deadly weapon. In count 2, the lesser included offense there being a robbery. Mr. Parra, will you confirm that for me as well on cause number 3572?
Yes, Your Honor.
Okay, so I want to go back because I think when we broke, I skipped over that case. So Mr. Tarin, in cause number 2022-0D03572, as to count 1, aggravated assault with a deadly weapon, what is your plea, guilty or not guilty?
Guilty.
And as to count 2, the lesser included offense of robbery, what is your plea?
Guilty.
Okay, and again, you're making those pleas freely and voluntarily?
Yes, ma'am.
Okay, I'll find you're making those pleas freely and voluntarily as well. Mr. Vandenberg, would you please continue your summary?
yes, Your Honor. Again, in around the 20th, on or about the 20th day of June 2022, the state would have been able to prove beyond a reasonable doubt that David Tarin did it then and there as a member of a criminal street gang, intentionally and knowingly commit the offense of aggravated assault with a deadly weapon. And it is further presented that a deadly weapon, namely a knife, that in the manner of its use and intended use was capable of causing death and serious bodily injury, was used or exhibited during the commission of the charged offense during the immediate flight following the commission of the charged offense. That the defendant used and exhibited the deadly weapon. In count 2, This is not working here. The same date, Mr. Tarin did then and there, as a member of a criminal street gang, intentionally and knowingly commit the offense of aggravated robbery, and is further presented that a deadly weapon, namely a firearm, was used or exhibited during the commission of the charged offense during the immediate flight following the commission of the charged offense, and that the defender used and exhibited a deadly weapon. In the matter that ends in 5573, deadly conduct, discharge of a firearm, the state would have been able to prove beyond a reasonable doubt that on or about the 5th day of August 2022, and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, David Turin, hereinafter referred to as defendant, did then and there knowingly discharge a firearm at or in the direction of a habitation, and the defendant was reckless as to whether the habitation was occupied, namely by discharging said firearm in the direction of said habitation without determining if said habitation was occupied. And is further presented that a deadly weapon, namely a firearm, was used or exhibited during the commission of the charged offense. The defendant used and exhibited the deadly weapon. In the fourth cause that ends in 4719, aggravated assault with a deadly weapon is count 1. The state would have been able to prove beyond a reasonable doubt that on or about the 25th day of April 2022, and anterior to the presentment of this indictment in the county of El Paso and the state of Texas, David Turin, hereinafter referred to as defendant, that then and there intentionally or knowingly threatened Dominique Barunda with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a knife. That in the manner of its use, intended use, was capable of causing death and serious bodily injury, and is further presented that the defendant used and exhibited a deadly weapon, to wit, a knife, during the commission of the offense. As for count 2, in the same date, the defendant did then and there intentionally or knowingly cause bodily injury to Dominique Barunda, hereafter styled the complainant, a child of 14 years of age or younger, by striking the complainant about the face with the hand of the defendant. That is the end of the indictments. The state would request that exhibits 1 and 2 be admitted to evidence on all matters, Your Honor.
States 2 being the 3914 disclosures. Mr. Barra, is there an objection?
No objection, Your Honor.
States 1 and 2 are admitted as to each case. What is the agreement?
The state would recommend on all matters that the defendant be sentenced to 3 years confinement in the Texas Department of Criminal Justice Correctional Institutions Division with no period of community supervision.
Mr. Barra, is that your understanding of the plea agreement?
Yes, Judge.
Mr. Tarin, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial and by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. Is a document that explains your appeal rights. Because these are plea, bargained, or negotiated cases, you do not have an automatic right of appeal. Mr. Tarin, do you recall reviewing the trial court certification with your attorney and signing those documents?
Yes, ma'am.
They were signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2022-0D05573, I will find you guilty of deadly conduct, discharging a firearm, and sentence you in accordance with the plea agreement. Let me go through the rest of the cases. In 2022-0D04719, count 1, I will find you guilty of aggravated assault with a deadly weapon, and in count 2, find you guilty of injury to a child or elderly. As to count 1, there will be a deadly weapon finding. In cause number 2022-0D03572, count 1, aggravated assault with a deadly weapon, I will find you guilty of that. And to count 2, find you guilty of robbery. In cause number 2022-0D03238, I will find you guilty of the lesser included offense of robbery. As to each of these cases, I will sentence you according to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. All cases will run concurrent with one another and you will receive credit for any and all time which you have served. I understand pursuant to this plea, there is a dismissal forthcoming in cause number 2023-0D02136. Anything further on the new cases?
Not from the state.
No, Your Honor.
Okay. Now let's go to your probation case. That is 2020-0D05125. So are you the same individual who on August 17, 2021 entered a plea of guilty to the offense of theft of property in an amount between $2,500 and $30,000 and were given 5 years deferred adjudication? Are you that same individual?
Yes, ma'am.
Mr. Parra, do you waive formal reading of the motion?
Your Honor. Yes, we do.
Okay. Mr. Tarin, there were documents with respect to your plea of true plea papers and for your probation case, so to speak. Did you read those documents with your attorney? They were marked as States Exhibits 1, 2, and 3. Did you read those?
Yes, ma'am.
And you understood everything contained within those documents?
Yes, ma'am.
Mr. Parra, did you explain to your client the possible consequences of signing these documents?
Yes, Your Honor.
And Mr. Tarin, are you intelligently, knowingly, and voluntarily waiving the rights explained in the documents that you signed?
Can you repeat that?
Are you knowingly, intelligently, and voluntarily waiving the rights in the documents that you signed?
No.
I'm sorry?
No, ma'am.
No? So I
Um,
have plea papers that, well, they're not plea papers. They're STIPs and a waiver that was different from the plea papers in the other cases. This is with respect to your probation case. Do you recall reviewing those with your attorney?
yeah. I signed them. Sorry. Yes.
Okay. Did you, so did you knowingly, intelligently, and voluntarily waive the rights in those documents that you signed?
Yes, ma'am.
You understand that by signing them, you're giving up certain constitutional rights?
Yes, ma'am.
You understand that you are making a judicial confession?
Yes, ma'am.
You understand that on your plea of true in all probability, I will find the allegations in the state's motion to be true, and in all reasonable probability, I will find you guilty of the offense of theft of property. You understand that?
Yes, ma'am.
With regard to the motion to adjudicate, do you wish to enter a plea of true or not true?
True.
My understanding that the plea agreement in this case is 24 months in the state jail facility. Is that correct?
Yes, Your Honor.
Mr. Parra?
That's correct, Judge.
Mr. Tarin, is that your understanding as well?
Yes, ma'am.
Okay, I will accept the plea agreement, admit States Exhibits 1, 2, and 3 into evidence. The court will take judicial notice of all the documents in the district clerk's file in this case. Mr. Tarin, based on the evidence presented here today and on your plea of true, I find there is sufficient evidence to support the allegations in the state's motion, and I will find you guilty of the offense of theft of property in an amount between $2,500 and $30,000. And I will amend the judgment in this case from 5 years deferred adjudication to 24 months confinement in the Texas Department of Criminal Justice State Jail Facility. All of these cases will run concurrent with one another, and you will receive credit for any and all time that you have served. Anything further, Mr. Vandenberg?
Not from the state, Your Honor.
Mr. Parra?
No, Your Honor.
Thank you very much. Good luck to you, Mr. Tarin.
Thank
Who's
you.
next?
We have one more one, Mr. Parra, Judge, bottom of page 16.
Okay.
Annex, may we have Ibanez, Luis Alberto.
A bond hearing, Your Honor.
Got it. Thank you. Ms. Welch, can you tell me the bond amounts, please?
Ibanez.
On Ibanez?
Yes, Judge, the case is loading for me. I'm sorry.
You're fine, thank you. Is that your client, Mr. Popper?
Yes, Your Honor.
Thank you.
So, out of this court, he has, for 7,500 cash surety on the theft of property charge, and on the possession of a controlled substance, it's 5,000 cash surety.
All right. Go ahead and call him, Mr. Marujo. Thank you, Ms. Welch.
In cause number 2023-0D01360 and 2023-0D00519, State of Texas versus Luis Alberto Ibanez. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
Manuel Parra, Your Honor, from Mr. Ibanez, also ready.
And Mr. Ibanez is appearing remotely from the jail annex. We're set for a bond hearing. Mr. Parra, you may proceed.
Your Honor, Mr. Ibanez also has some cases out of County Court 7. We were scheduled for a bond hearing then. Even though the state was in agreement for a PR bond, given the amount of time that Mr. Ibanez has been in custody, Judge, the court deferred to to the 210th judge to see what would happen here. And Your Honor, Mr. Ibanez has been in custody for 228 days. And he, frankly, I think should have been set for a bond hearing far before today, Your Honor. There is a probation recommendation on the table that Mr. Ibanez is aware of and knows would result in his release. However, there's some aspects about the case that he wishes to challenge the judge and would be requesting the court instead consider a PR bond. Your Honor, Mr. Ibanez, I'm sorry, you might have to remind me, do you have somewhere to work if you get released?
Yes, sir.
Okay, and remind me where that is.
It's at the Marriott.
Okay. And Your Honor, otherwise, he is able to maintain a household here in El Paso, Judge, especially given that employment opportunity. All of his ties are to El Paso, Your Honor. He's not a flight risk whatsoever.
Okay, so the PR revo, I guess what, let me go look. November 8th, back when he was on PR bond, he was failing to report or provide correct information to CJC. Let me look into this, and Mr. Vandenberg, go ahead.
The state opposes that request, Your Honor. In particular, the bond for the possession. Mr. Ibanez has 2 prior PCS misdemeanors, and the labs are in on this. This is a strong case against him.
But is it a probation rec?
We don't have a probation record right now, Your Honor.
What
I could have
is it?
sworn we were at 5 AP. I'm sorry.
Five. Oh, that rec. Yes, Your Honor. It's 5. The rec is 5 AP tap, 42, $2,000 fine, 300 hours community service, UABA's curfew.
Okay.
And it runs the same with the other case, Your Honor.
Okay, what else on the bond?
That's mainly it, Your Honor. We think that he's a danger to the community because of his use of meth. And there's also the issue of the theft. It was a theft of an automobile, Your Honor.
So where is he gonna live, Mr. Potter? He has a place to live, he has,
Yes, what's the address on that, Mr. Ibanez?
210 Pendale Road,
and how long has he lived in El Paso?
all my life.
Born and raised, Judge.
So I'm looking at the PSR. What happened with these? It looks like he has some cases on the federal side. What was the probation violation there? Was it our cases or what was it? Mr. Potter, let me also ask you, I'm
Sure.
looking, so we have never we have never had a request for a bond hearing, right? I don't recall reviewing his
Not on my
bond.
calendar, Judge. This is one of the cases that I had taken over around December, January, Judge. But
okay.
even then, I can't explain why we didn't set it for a bond hearing before today.
I see there was one on December 31st, and that could, I don't know. I don't think we worked on New Year's Eve. I know we were doing a few bond hearings. So you're opposed to any bond reduction, Mr. Vandenberg?
Yes, Your Honor.
His family's here, Mr. Parra?
Yes, Your
Everybody-
Honor.
Well, the possession, 3rd degree, you're offering probation, and we have a trial in 3 weeks, 2 weeks. Are you all going to be going to trial, Mr. Parra? Actually, it's September 1st.
It's September 1st, Your Honor. I don't anticipate having to announce not ready, Judge. We could be ready for trial in September if it need be, and if it doesn't resolve itself before then.
Okay. I'm assuming you're asking for a full PR bond?
Yes, Judge, and in the alternative, a split bond of some kind, given.
I'll split them. I'll split 1360. I'll split it 2,000 cash surety, 3,000 PR. conditions will be to report monthly UABA curfew, subject to testing, commit no new offenses, may not leave El Paso County or change his place of residence without court permission. I will also split the 4072, wrong. 0519. That will be a 2,500 cash surety, 5,000 PR, same conditions. Okay. All right.
Understood, Judge.
I'll say this, Mr. Parra, if it becomes less, if your client is more inclined to plead, let us know sooner than later
Of course.
if he can't bond out, okay?
Understood, Your Honor.
All right, thank you very much.
Thank you.
Who's next?
Judge, we're still missing bottom of page 17. Mr. Avila I just called their office. He was going to log in.
Well, I'm gonna reset Ms. Puga for 1 week because all we're waiting for is the plea paperwork to be sent to council so we can sign her up.
Yes, Judge.